Welcome back to Upfront. A former Wauwatosa police officer who escaped being charged in a fatal shooting may now face charges after all. Milwaukee County's district attorney decided not to charge former officer Joseph Mensah in the 2016 death of Jay Anderson, concluding it was justified self-defense. But a county judge ruled there is probable cause to charge Mensah. The judge will appoint a special prosecutor who will decide whether to charge Mensah, who is now a Waukesha County Sheriff's detective. Anderson's family pursued the case under a rarely used legal process. So we're talking more about this with criminal defense attorney Dan Adams. Thanks for bringing your perspective to the show. So how rare would you say is this decision from the judge?
Thank you, Adrian. It's very rare. The use of the John Doe law in this way is kind of the Halley's Comet of criminal procedure in the state of Wisconsin. We just don't see many cases going to a full hearing. And I can't remember one where a judge actually found probable cause and agreed with the petitioning party.
What's the reaction right now in the legal community, have you heard?
Well, I'm surprised. This was an earthquake in the Milwaukee County Courthouse. People were surprised that Judge Yamahiro, who's a long-serving member of the judiciary, found probable cause here. And I think we're waiting to see what happens next, which is essentially he's going to appoint a special prosecutor, somebody outside of the Milwaukee County District Attorney's Office, to come in and step into the role as the prosecutor. And that special prosecutor has their own decision-making to make.
Considering the district attorney decided not to charge in this case already, going forward, what do you think are the chances of Joseph Mensah getting charged?
Well, the chances are better than they were last week. Let's just say that. Again, you have John Chisholm's district attorney's office considered these same facts and came to the conclusion that they could not bring a case against Joseph Mensah. They found that they believe that they can't prove it beyond a reasonable doubt. And these are professional prosecutors who look at cases all day. So you have a circumstance where probable cause has been found, but perhaps a reviewing prosecutor will say, even though there's probable cause, we don't ethically think we can prove the case in front of a jury of 12 people beyond a reasonable doubt. And those two standards are different and have real legal meaning.
What type of precedent is this setting? I mean, do you think other families might see this and say, hey, you know, we lost our loved one to a police officer shooting, maybe we should try this outlet?
Certainly. I think anytime you have a successful venture in the law, people will try to replicate it. And I don't think it's controversial to say that there's a lot of distrust in pockets of this community and around the country about law enforcement. And many people believe that prosecutors and police are too close. And because of their working relationships, the prosecutors couldn't possibly be fair and objective in reviewing police shootings. So I think that this case will crack the door to other families attempting to use this John Doe process to get the ball rolling for a criminal case.
We'll see what happens. Dan Adams, criminal defense attorney. Thank you.
Thank you.
Next, there have been fewer than 100 successful veto overrides in the history of state government. So why even bother?